Nobody reads the terms of service. The people who wrote them know this. They designed them that way. In 2008, researchers at Carnegie Mellon University calculated that reading the privacy policies of every website the average American visits in a year would require 76 workdays. The calculation was not a critique of user behavior. It was a documentation of institutional design. The terms of service is not written to be read. It is written to be accepted. Those are two different objectives, and only one of them has anything to do with a contract. By the end of this video, you will know exactly how the terms of service functions as a compliance ritual rather than a legal agreement, which historical institutional systems developed the architecture it is built on, and why a document that no one reads and that grants rights no one understands has become the primary legal infrastructure of the largest transfer of behavioral sovereignty in recorded history. The signature was always the mechanism. The terms were never the point. A contract in the legal tradition that produced the terms of service requires three elements to be valid: offer, acceptance, and consideration, something of value exchanged by both parties. It also requires, in most legal traditions, that the terms be reasonably knowable to the party accepting them. The terms of service fails the knowability requirement by design. A 2019 study published in the journal Policy and Internet documented that the average terms of service document for a major technology platform requires a college reading level and between 30 and 90 minutes to read in full. The study also documented that the median time users spend on the terms of service screen before clicking Accept is 6 seconds. 6 seconds, 30 to 90 minutes of content. One click. This is not a failed contract, it is a successful ritual. The distinction matters precisely because rituals and contracts are different technologies with different functions. A contract transfers specific defined rights and obligations between parties who understand what they are agreeing to. It functions through comprehension. A ritual produces a behavioral and psychological state, compliance, membership, submission, transformation, through the performance of a prescribed sequence of actions, independent of whether the performer understands the meaning of those actions. It functions through participation, not understanding. The terms of service produces compliance through participation. The user clicks accept. The click is the ritual gesture. The legal text is the sacred language, present, authoritative, and unread, exactly like the Latin Mass before the Second Vatican Council, which was performed in a language the congregation did not speak for precisely the same institutional reason. Comprehension is not the point. Participation is the point, and participation produces the state of institutional membership that the ritual is designed to create. This is not a metaphor. It is a documented institutional parallel with a specific historical transmission. The legal instrument most directly ancestral to the modern terms of service is the adhesion contract, a standardized, non-negotiable agreement offered on a take-it-or-leave-it basis by a party with superior bargaining power. The adhesion contract was formalized in French legal theory in the early 20th century and entered American commercial law through insurance and transportation industries in the 1920s and 1930s. But the adhesion contract's institutional logic predates its legal formalization by several centuries. The feudal oath of fealty, the formal agreement by which a vassal acknowledged a lord's authority and accepted the obligations of the feudal relationship, was a non-negotiable, standardized document offered by a party with superior power to a party with no meaningful alternative. The vassal did not negotiate the terms. The vassal performed the ritual, the physical gestures of submission, the spoken formula, the acceptance of a prescribed sequence of actions, and through that performance became bound by obligations whose full scope they often did not comprehend. The institutional logic is identical. A party with superior power presents a non-negotiable set of terms. A party with no meaningful alternative performs a prescribed acceptance ritual, and the performance of the ritual creates a binding relationship regardless of whether the accepting party understood what they agreed to. The transmission from feudal oath to adhesion contract to terms of service is traceable through a specific legal lineage. In 1964, the U.S. Supreme Court case Carnival Cruise Lines v. Chute established that contractual terms printed on a ticket terms the purchaser had no opportunity to review before purchase and no practical ability to reject, were legally binding. The court's reasoning: the purchaser's act of using the ticket constituted acceptance of the terms, regardless of whether those terms had been read or understood. The click-wrap agreement, the direct ancestor of the terms of service, was validated in the 1996 case Pro CD versus Zeidenberg, which established that a user's act of installing software constituted acceptance of license terms displayed during installation, even if those terms were not fully reviewed. The click was the acceptance. The comprehension was irrelevant. By 2005, every major technology platform had adopted the click-wrap model. By 2010, the average technology user had clicked accept on terms of service agreements, granting platforms rights over personal data, behavioral data, communication content, and in some cases intellectual property, without reading, without negotiation, and without any meaningful understanding of what had been transferred. The feudal vassal's spoken oath had become the user's mouse click. The lord's castle had become the platform's server. The fealty relationship had become the data license. The ritual structure was identical. Here is where the compliance ritual analysis produces a precise diagnostic. The terms of service is not one document. It is a system of ritual elements, each performing a specific compliance function. Understanding the system reveals why it works so reliably on a population that knows at some level that it is not reading what it is accepting. Wait, look at the structure again. The length is the first ritual element. The document's length is not a consequence of legal complexity. It is a designed feature. A document long enough to be practically unreadable communicates two things simultaneously. First, that the institution is thorough, serious, and legally sophisticated. The length signals legitimacy. Second, that the user's non-reading is normatively expected. The length makes non-reading the rational choice, which means the institution has designed a system in which the rational response to its legal document is to not engage with its legal document. That is not a drafting choice. It is a compliance architecture. The language register is the second element. Legal language serves a specific institutional function in the terms of service that is independent of its legal precision. Dense, technical prose signals that the document belongs to a domain of expertise the user does not possess, that understanding it would require professional translation. This signal produces institutional deference. The user who cannot pass the language is positioned as a layperson in relation to an institutional expert, and laypeople defer to institutional experts on matters within the expert's domain. The language produces submission through incomprehension. The scroll requirement is the third element. Most terms of service interfaces require the user to scroll through the entire document before the accept button becomes available. The scroll requirement performs the ritual of due diligence. The user must perform the motion of reading, even without reading, to complete the acceptance. The motion is the ritual. The comprehension is not required. Van Gennep's liminal threshold appears here in a specific form. The scroll is the processional movement through the ritual space that precedes the threshold crossing of the click. The accept button itself is the fourth element, and the most precisely engineered. The button's language, I agree, accept, I accept, is in the first person. The user does not click a button that says, platform receives license. The user clicks a button that says, I agree. The first-person framing makes the user the agent of the agreement. It is the user's voice, the user's word, the user's identity that the ritual mobilizes. The click is a speech act in the legal sense, a performative utterance that constitutes the action it names. The user says, I agree, and through the saying, agrees. The comprehension of what has been agreed to is structurally absent from the mechanism. If this investigation is worth continuing, signal it. The algorithm reads that as a vote for independent analysis. Here is the applicable lens. The next time you encounter a terms of service acceptance screen, do not evaluate it as a failed communication. Evaluate it as a successful ritual. Ask which ritual elements are present: the legitimizing length, the deferential language register, the processional scroll, the first-person acceptance button. Then ask what rights are being transferred in the moment of the click. not in full legal detail. That is the point of the system, that you cannot know quickly. Ask in general categories: data rights, behavioral rights, communication rights, content rights. Most platforms' terms of service transfer all four. The click transfers them simultaneously, in 6 seconds, without negotiation. The feudal vassal who spoke the oath of fealty could not withdraw the oath after speaking it. The platform user who clicks accept cannot unclick. The transfer is complete at the moment of the ritual gesture, regardless of comprehension, regardless of meaningful choice, regardless of whether any genuine negotiation ever occurred. The next layer of this investigation goes deeper into how terms of service agreements are now being used to establish legal precedents for data ownership that will determine the regulatory framework for artificial intelligence training, and which provisions in currently active terms of service documents have already transferred rights that most users would not have agreed to if those provisions had been explained in plain language. Subscribe to follow the analysis. The question is not whether the terms of service is a compliance ritual rather than a contract. The Carnegie Mellon research, the legal history of adhesion contracts, and the 6-second acceptance window all confirm that it is. The question is, what was transferred in the last ritual you performed?